are here to hear the oral arguments in the case of Molnar versus the City of Green et al. Each party will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, let me know when you come to the podium. We'll be keeping track of the clock, and hopefully if that's working, you'll be able to keep track for yourself. The arguments are being visually and audibly recorded to be posted online, so please keep your voices up and remain behind the podium. We have read your briefs and we are ready to proceed when you are.
May it please the court. My name is Frank Scaldone and I represent the City of Green, Law Director Calta, as well as Mayor Neugebauer. I'd like to reserve 5 minutes of my time for rebuttal. This case comes before the court on the trial court's denial of immunity in a 12B6 case. It was previously before the court. This court found in the previous appeal that the opinion that was drafted, well, it actually wasn't an opinion, was not sufficient for appellate review. Remanded it back down to the trial court that issued another opinion that I would submit that even that with regard to immunity doesn't tell in any meaningful way what exception of immunity would apply to any of the defendants. So today I'm here before the court to ask the court to reverse the trial court's denial of immunity and grant immunity in favor of my clients. The trial court erred in this matter for 2 reasons. One, the plaintiff did not establish an exception to either the political subdivision's immunity or the individual's immunity under 2744. And 2, complying with a court order to produce records can never constitute an exception to immunity under Ohio's Political Subdivision Tort Liability Act. Turning to the City of Green, Ohio political subdivisions, like the city, are entitled to broad immunity, a presumption of immunity. And that is incumbent upon, when raised, it's incumbent upon the plaintiff to come forward and establish one of the 5 exceptions that are under 274402B1 through 5. Here, the plaintiff did not argue that any exception applied, did not argue at the trial level, did not argue in the previous appeal, did not argue in this appeal that any of those 5 exceptions apply in this case. Rather, what the plaintiff has tried to do is to couch this claim as a contract action. As you're probably aware of, 274409 cases that are contract claims are pulled from the provisions of the Immunity Act.
Well, they didn't even try to. They did, in fact, file a claim as a breach of contract, correct?
I would disagree with it on this ground. One, to be clear, the Supreme Court of Ohio has expressly held that a public entity cannot enter into enforceable promises of confidentiality regarding public records, and that's State Ex Rel. Findlay Publishing Company, 80 Ohio State 3rd, 137. There's no dispute that these are public records. The plaintiff has admitted this. The Court of Claims has found that. The 9th District has held that a contractual promise of confidentiality with respect to an otherwise public record would violate the public records law if enforced. And such provision in agreement, and this is the important part, is void ab initio. Void ab initio is if a contract never existed. So my position is that here you have and I understand on the paper it's been written obviously that they're alleging a contract claim, but it can't be. It's as if the contract never existed of law because of the nature of it. It's not an affirmative defense. It is void ab initio, as it never existed. I would also point out, if you actually read that letter, the basis for the contract action is that this letter created a binding contract of confidentiality on the city. But if you read the letter, actually, and something that the plaintiff doesn't point out in his briefing, it's quote, and it's Exhibit A to the complaint, so it is part of the appellate record here. Quote, we have further agreed to keep the terms of the resolution of your employment with the city confidential. And here's the important part. except to comply with public records requests, end quote. So even if you were to look beyond the fact that it cannot be a contract as a matter of law under the precedent that I stated, even looking at that, I mean, there's no, I mean, the position that he's taking simply doesn't make sense even under that letter.
Counsel,
So,
one of the things I'm struggling with is
Yeah.
the fact that it seems like we're really arguing summary judgment instead of a motion to dismiss.
I disagree with that because of the legal nature of, I mean, if you look at the case law, I mean, it's pretty clear, this is a legal issue, and you can't enter into,
Go ahead.
you can't enter into a contract that is going to be in violation of the public records law, and as the courts have held, it's just as if it never existed. So I disagree that it would be a summary judgment issue. It can be and should be decided as a matter of law as early as possible, as you know, as I'm sure you're aware, the Political Subdivision Tort Liability Act is designed to try and eliminate these types of claims at the earliest opportunity before discovery, before additional impositions are placed on employees of political subdivisions.
I understand what you're saying. I guess I'm just wondering because it seems like there's a lot of facts as to what actually they were talking about, what actually transpired. The Court of Claims decision was not in front of the court. Those type of things.
Yeah, and I don't think any, but first, you can disregard, I mean, we've taken the position that you could take judicial notice of the briefing in the Court of Claims. But you you can disregard that completely and still reach the correct ruling in our belief that the trial court erred in denying immunity. It's a pure legal issue.
But to get to that point, the trial court would have to decide not only that a political subdivision can't enter into that type of contract, but would also have to make the determination that it was in fact an illegal contract, and on top of that, we have to determine that the letter was a public record. There's a lot of steps there that you have to get through on a 12b6.
I think they're answered in that case law, candidly. I mean, if you look to the Supreme Court precedent that designates it, and actually the plaintiff admitted it's a public record, so that's not even really an issue. The Supreme Court of Ohio has came out, and not to belabor it, but cannot enter into enforceable promises of confidentiality regarding public records. So again, it's going to be void at its inception.
But that's assuming it is a public record.
I don't think there's, like I say, I mean, it's alleged. I don't think there's any question that it's a public record.
I'm not sure they agree, but that's
Well, certainly right now they don't, as we're speaking about it. But up to this point, there hasn't been much of an argument to that effect. So, with regard to
You're catching me thinking.
no, I can continue.
Could be a scary thing.
You let
I guess, going to the facts, and I think at least there's some allegation of these in the complaint. The agreement, what's the time frame between the agreement and then the seeking of the records from the TV station?
I'm not sure that is, I'm not sure that that's, my memory escapes me. I'm not sure if that's explicit in the allegations in the complaints. And that's the record that I'm working with. So I can't answer that. I know that ultimately there had to be a great deal of time between the request and when it was actually produced, because it went through litigation in the Court of Claims, which actually was alleged in the complaints.
Right, and I know that. That's why I just wondered, because isn't there argument that putting aside whether this was or wasn't a public record, it wouldn't have mattered, because if Green followed the agreement as Mr. Molnar sees it, it wouldn't have existed to produce or to have been available to produce?
Again, you can't destroy public records.
So then why say you're going to?
Well, if you actually look, and I know we're talking about the legal issue of immunity, but I invite you to look at the attachment that expressly states, this is Exhibit A to the plaintiff's complaint, quote, "We have further agreed to keep the terms of the resolution of your employment with the city confidential, except to comply with public records requests," end quote. So they didn't you know, they didn't enter into an agreement that they couldn't under Ohio law. But setting that aside, I mean, it's a legal matter based on the case law that I cited in.
So now I'm sorry, but I misunderstood perhaps. Now you are agreeing that it was a legal contract? Because you said they didn't enter into a contract that they
Well, no,
couldn't enter into.
my position is because of the case law, it's void at its inception, and what that means.
Why would it be void at its inception if they agreed not to destroy anything that's a public record?
Well, the position that the plaintiff is taking is that that part of it is enforceable, and that's what his case is completely about. So that's where that argument comes from. What I'm saying in the alternative, and I apologize if I'm making it more confusing than it needs to be, was that even if you look, the absurdity of the claim itself is kind of undone when you look at the language that's actually part of the letter that's supposed to be the contract. But
Excuse me, you're now right with 5 minutes of your total argument left. You're welcome to proceed with your rebuttal time if you want to.
I will say because there are other defendants here that are important to discuss because there really are no factual allegations of the high level of culpability of malice, bad faith, wanton, and reckless. But I will be happy to discuss that with the court after opposing counsel's presentation is done. Thank you.
Good afternoon, Your Honors. My name is Brian Carr, and I represent the appellate Nick Molnar. It's a pleasure to be before you again. Judges Callahan and Schaefer I've not met before, but Judge Carr, it's a pleasure to see you again. I want to take issue with two things that counsel said. First, he characterized the plaintiff's claim as absurd, and I take a little bit of offense to that. We haven't gotten to any point of any kind of discovery as of right now. So for counsel to take the position that the claim is absurd, I think sells the plaintiff a little short. One other comment that plaintiff's counsel, appellant's counsel made, and he did it at the last oral argument, and I made reference to it at the last oral argument, is he indicated that plaintiff admitted that this was a public document. There's never been any admission to that at all. I'm not sure where that's coming from. The appellee filed a complaint and an amended complaint. They filed a motion to dismiss. There was no discovery of any kind, no written discovery, no deposition, so I don't know what admissions counsel is talking about, that this was a public document. Maybe he'll let us know, but that's the second time it was stated, and I just want to set the record clear that there was no admission of any kind that this was a public record.
So is it your contention that it is not a public record?
There's a dispute as to whether or not that's a public record, sure. Because the problem that I have is...
Is that a matter of law?
Well, I think there's going to be a factual determination as to whether or not that's a public document, because conceivably, there's case law that says that any document that's created by a public entity is a public record. You know, and that's a broad characterization. If that were the case, then a municipality or a municipal officer or employee can create any document in bad faith or good faith, and it's a public document. And so I think there's an issue of whether or not that's a public record or not. But I think Judge Carr hit the nail on the head. This is not a public record case. This is a breach of contract case and a defamation case. That's how the complaint was styled. The contract was attached as an exhibit to the complaint.
I actually think that was Judge Callahan, but that's okay.
I apologize, Judge Callahan.
Doesn't matter to me.
That's
We're
exactly...
interchangeable.
That's how the complaint and the amended complaint were styled and fashioned as a breach of contract case. Now, the problem with counsel's argument about how immunity exists and this and that is if you want to take judicial notice of the Court of Claims case, and I suppose you can, but it's not res judicata because my client was made a party, and I addressed that, I believe, in some of the filings in the court below and perhaps this court, is that in the Court of Claims filing, the City of Greene acknowledges and admits that they did destroy copies of that letter. Because apparently there were copies of that letter floating all around the City of Greene in all these various departments. And what the law director acknowledged in a number of filings in the Court of Claims is that the city destroyed a lot of copies of it, but there happened to be one left in the personnel file. That goes right to the panel's questions about questions of fact, issues of fact. and why a 12B6, it's simply not available right now. All allegations in the amended complaint are presumed to be true, and I believe, and even though we're a notice pleading state, I have a tendency to over-allege in my complaints, and I believe my amended complaint contains a lot of allegations, and in fact, they quote from the Court of Claims briefs so that I can make the point to the court that the City of Greene and its law director are telling the Summit County Common Pleas Court one thing, and they've told the Court of Claims something totally different, totally inaccurate. That's why we have discovery, to flesh these out. That's precisely why this case is fact-driven. And there is case law directly on point that I filed in my brief and op to the motion to dismiss, that there are contracts that a municipality can enter into to, I don't want to use the word destroy in a pejorative fashion, but to destroy records. If there's an allegation that it could be defamatory or false, you can absolutely enter into a contract. I was assistant to a law director for the city of Mayfield Heights for many years. Okay, I understand that. The case law backs that up, that municipalities can enter into such contracts. They are not void ab initio. The contracts that council wants to refer to in his brief, they don't apply here. The law director approved that contract as to form. Going back to one of the panel's questions, I believe that that contract was entered into in around the May timeframe, and I believe Channel 19 requested it maybe 8 months later. It wasn't very long, because it was a hot political topic, I suppose. So all of this happened very, very quickly to my recollection. And again, I believe my complaint is very detailed in terms of the dates, Your Honors, and so I believe that my complaint will back me up. Immunity, there are also issues of willful and wanton misconduct, and how the city of Greene acted in this case.
Counsel, that brings me to a question. In reading your complaint, there were quite a few allegations as to how the city of Greene acted, its mayor and its law director. I didn't necessarily notice how they acted in a personal capacity, or I mean in a capacity that would make him liable personally. You want to address that? Because I'm guessing that's coming up on rebuttal.
Perhaps, absolutely, Your Honor. You know, my position is that when you have official actors or employees or agents of a municipal corporation that act in a willful or wanton manner, that takes them out of the personal realm, out of the official realm and into the personal realm. But again, going back to what I was arguing, is that those questions, when you have immunity and you have allegations of willful or wanton misconduct, those are jury questions. And that's a direct quote from all the applicable legal authority that I've cited in my brief. Again, I understand the City of Greene's argument. However, when you have a case that is so fact-specific and fact-intensive like this one, 12B6 is simply a little premature. I believe I filed this complaint in early 2017. We're now in the spring of 2019, and not one deposition has been taken. I've been doing this long enough to know that the legal system is slow, and it takes time, and I understand. But my client, again, has been harmed, in my humble opinion, and it's been almost 2 years, and we really have gained no ground. So with that, I want to thank you for your time this afternoon or late morning, and I appreciate the opportunity to argue in front of you. It's always a pleasure. Thank you.
Counsel, you have 4 minutes and 31 seconds.
Thank you. I think it's important to start with the individuals because they are being sued in their personal capacity. While opposing counsel talks about all the facts that he's alleged, when you review the complaint, there are absolutely no factual allegations as opposed to legal conclusions that are alleged in this complaint, certainly against Mayor Neugebauer. There's no allegation of fact. In fact, the way that he makes the allegation is that the mayor acted recklessly, wantonly, in bad faith. Well, that's a pure legal conclusion. And legal conclusions under Supreme Court law, both in the United States and the Supreme Court of Ohio, do not give the presumption of truth to legal conclusions. The presumption of truth only comes with factual allegations. You can't simply say, the mayor defamed me, and allege a claim that's going to avoid immunity.
They didn't just allege that he defamed them. They talked about the agreement and how they had agreed to destroy every copy, but they didn't destroy every copy. And I think your allegation or your argument is, well, they weren't able to enter into that kind of agreement to begin with. And so therefore the contract was void
Void at its inception.
at its inception.
Sure.
So my question to you is, if that is the case, then how is it not alleged that these individual actors acted in their personal capacity? Because you can't, as a mayor, enter into an illegal contract. You can't, as a mayor, promise to destroy public records. Isn't that something that's outside the scope, of course, of their employment and would cause them to be personally liable?
I'm not sure if I completely follow the question, but certainly the overarching argument here is that there can be no liability, there can be no exception to immunity when you're talking about a purported contract claim that's not enforceable as a matter of law. So anything that flows from that is not going to impose individual liability on the law director or the mayor.
That's what I'm getting at. So I'm sorry, I know you got a little.
No, I'm just checking.
But the point is, what I'm saying is, let's take your argument and say that it is an illegal contract. How can a mayor, let's just say the mayor, enter into an illegal contract and not be personally responsible for that?
Well, he can't. I mean, the law provides that it's as if that contract never existed,
Right, so the city's not responsible.
and nor would the mayor be.
So there wouldn't be any allegation of fraud or misrepresentation or?
Well, there certainly wasn't in this case. I mean, there's no factual allegations against him demonstrating how he somehow defamed. It's just legal conclusions. And that's the point, that's my point with regard to both Law Director Calta as well as Mayor Newdegard. There simply are no factual allegations that get them to that point. Further, the issue of whether records documenting termination letters are public records, well, the court merely needs to look to State XRL Freedom Communications 82 Ohio State 3rd 581. So that's obviously a public record under the Supreme Court of Ohio precedents. With regard to destroying copies of the letter, there's nothing wrongful about destroying copies of a public record. The original, however, is a completely different matter, and that's something that a public entity cannot do.
So you're saying in all circumstances, let's say it's a mistake. We generate all kind of drafts, for instance.
I'm sorry.
We generate all types of drafts of cases,
Right.
okay? Now, I understand we're different because we're court, obviously. But let's just say there's 5 drafts of that particular letter before it actually gets in the final form. I assume you would not say every copy of that draft has, every original of that draft would have to be kept.
I mean, it's really highly, I guess what I'm saying here, I'm a little hesitant to go down that
That's
road.
all right.
But I am confident that if you have multiple copies of the same termination letter, that a public entity destroying those does nothing wrongful. They just can't destroy the original that they have.
But wouldn't the original termination letter have been the letter that was sent to the person terminated? You can answer that, and I'm sorry, your time is up.
Yeah, I mean, I think that, if you look at it, it's pretty clear in that letter that that there would have to retain a copy of that termination letter, which would be, hand quotes, the original.
Okay.
Was it actually delivered, it was actually delivered to Mr. Molnar,
That's my
the April
understanding,
5th letter.
yes.
Okay. Thank you, gentlemen, for your presentations. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted to our website and that of the Ohio Supreme Court.